Hello everyone, welcome to Legal 40. Thank you for the overwhelming response given to our previous video. Today, we will discuss the offense of sedition, which is an offense against the state and is defined in section 124A of the Indian Penal Code. Section 124A defines the, the offense of sedition as follows. Whoever, by words either spoken or written, or by signs or by visible representation, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, with imprisonment which may extend to 3 years, to which fine may be added, or with fine. The expression disaffection includes disloyalty and all feelings of enmity. Now, what do not constitute an offense under this section? Comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means, and comments expressing disapprobation of the administrative or other actions of the government without exciting or attempting to excite hatred, contempt, or disaffection. Now, these are the three explanations which are appended to the section. The constitutional validity of this section came up before the Supreme Court in the case of Kedar Nath Singh versus State of Bihar. This was a constitution bench, and the court held that provisions of section 124A are not unconstitutional, and they are not violative of the fundamental right of freedom of speech and expression under Article 19(1)A of the Constitution. Further, the court said that it is well settled that if certain provisions of law construed in one way would make them consistent with the Constitution and another interpretation would render them unconstitutional, the court would lean in favor of the former construction. In Common Cause versus Union of India, which again was a decision of the Supreme Court, in this case, the Supreme Court held that authorities, while dealing with the offences under Section 124A of the Indian Penal Code, shall be guided by the principles laid down by the Constitution Bench in the Kedar Nath Singh case. An important development took place recently in the case of S.G. Vombatkere versus Union of India, decided by a three-judge bench. In this case, the constitutional validity of Section 124A was challenged before the Supreme Court. In this case, the Union of India agreed that Section 124A IPC is not in tune with the current social environment and was intended for a time when this country was under the British rule. Union of India also agreed to re-examination to find out the manner in which the requirement of security interests and integrity of the state should be balanced with the civil liberties of citizens. The court stayed the operations of Section 124A and directed that no coercive action to be taken under this provision till the issue of constitutional validity was settled. The court issued directions with respect to pending FIRs, investigation, and criminal proceedings under Section 124A IPC. Further, central government to issue directions to state union territories to prevent misuse of Section 124A. Now this brings us to the end of this video. Thanks for watching. Send your comments and suggestions to legalforte1@gmail.com. Thank you.